Okay, our next witness is Elizabeth Samuels. And do you swear or affirm that the testimony you're about to give is true?
Yes, sir.
And would you state your name and talk a little more closely to the microphone?
Okay. Can you hear me?
Yes.
Okay. Well, first of all, Chairman Gottfried and members of the committee, thank you so much for the opportunity to testify, and thanks also to all the sponsors of the bill. My name is Elizabeth Samuels, and I'm a law professor at the University of Baltimore in Baltimore, Maryland, at the University of Baltimore School of Law. I teach there in the areas of constitutional law and family law. And since the 1990s, my scholarship has focused pretty much in large part on adoption law, particularly on the history and the current status of laws governing adoption records. What I hope to do is very briefly, in 5 minutes, summarize 5 points that I believe do support the passage of this bill. And then I hope to be able to answer any questions that you might have. I have laid out these points in somewhat greater length in my written testimony, and then that testimony, of course, has citations to my scholarly work, all of which, of course, is available online. And in those pieces, of course, I explain perhaps at interminable length with an ungodly number of footnotes supporting my research. What all of this adds up to is my belief that when one has an accurate understanding of the history and the legal history and the social history of adoption law and adoption records, that that understanding lends strong support, as has already been testified, to this bill in New York. And my most recent research, which I will mention in a moment, involves a study of a collection of surrender documents that were signed by birth mothers in 26 different states during the years from the late 1930s to 1990. And I think they are extremely helpful in understanding what the analysis of these documents, what they have to say, I think is extremely helpful. But first of all, I would like to say, again, just as a summary point, and it really supports, I think, what Member Borelli was getting at, the law has never guaranteed lifelong anonymity for birth parents. And when 2 of the states that have restored access that was formerly denied to adult adoptees, Tennessee and Oregon, the laws were challenged, restoring access in state and federal courts. And the courts held that the laws did not violate federal or state constitutional law. They did not violate state statutory law, which is very similar to New York law, and they didn't violate any precepts of contract law. And in all the other states that have restored access, there have not been legal challenges. Again, as I think has come out clearly, adoption records have been accessible in New York, as they were in Tennessee and Oregon, by court order, if necessary, without notice to or participation by birth parents. Around the country, it's typically been up to the adoptive parents, not the birth parents, whether even to change the child's name or have a new birth certificate issued. So, secondly, regardless of any legal guarantee of lifelong anonymity, as has been testified, and I think the documents are particularly illustrative of this, birth mothers have not been offered a choice of or guaranteed even confidentiality by adoption agencies and by other facilitators. The documents that I collected, and there are 75 of them, again, from 26 states, a dozen are from New York. They're from private and public agencies. And from private and public agencies, from state to state and decade to decade, they are basically the same in their legal import and their provisions. And as Adam testified, no opponent of adult adoptee access to original birth certificates has ever produced a dissimilar document. In these documents, the birth mother, and she signs them to surrender, as was mentioned, the child, the rights to the child, before there's any adoption proceeding. And she does not retain or gain any rights of any kind in these documents. She's never promised any, even confidentiality. In fact, she's not promised that the child will be successfully placed for adoption. That's the hope, of course, a successful adoptive placement, but it's not a promise, and it may not occur. There can be permanent long-term foster care or institutionalization, and it's specifically provided that she will not have notice of any future proceedings regarding the child. However, 40% of these documents, including 3/4 of the ones I have from New York, again, the New York ones are also from the 30s, 40s, 50s, 60s, 70s, they do include promises about the future. It is the birth mother who makes the promises. She promises she will not induce the child to leave the family or the institution in which he's placed. She promises that she knows she has no right to know the child's new name or whereabouts. She promises she won't interfere with or harass the adoptive family. For example, actually, a 1966 Spence Chapin Adoption Service surrender document says as follows: "The undersigned does hereby agree and pledge not to interfere with the custody, control, care, or management of said child in any way, or encourage or allow anyone else to do so." That's a typical provision. Thirdly, and I'll pose this as a question, did birth mothers, even though they signed these documents and the law did not guarantee lifelong anonymity, did they desire it? As you've heard, and I will add in my own research into the history, the evidence is that birth mothers who sought confidentiality sought it from either their own families or from members of their community. Not that they were looking for being forever unknown from the child that they bore and forever unable to know if that child has lived or died and how that child has fared in life. And of course, that historical evidence is entirely consistent with also what you've heard, that the practice today, or the evidence today, is that the overwhelming majority of birth mothers, some 95% up, are even open to contact with their now adult children, and that the norm today in domestic infant adoption is openness. It seems to me those facts are consistent with the history, that was not what birth mothers were seeking. Fourth, and consistently with the first 3 points, when these records were closed around the country to inspection by the parties to the adoption as well as to the public, they were closed to protect, all the legislative histories show that they were closed to protect adoptees and adoptive families' privacy, and understandably, to protect adoptive families from possible interference or harassment by birth parents, not to protect the birth parents' lifelong privacy. And the surrender documents that I studied, I think, are just one piece of evidence among many of that historical fact. The fifth point I would make, and again have made at greater length elsewhere, is that in those states that never denied access, and as Adam testified, in those states that have now restored access, access has really proved to be beneficial and it has not been harmful. In those states, we don't have this kind of arbitrary and artificial division between adoptees who, without the birth certificate, are able to find out information about their original identity and those who are not. In those states, as you've heard, birth parents have been given an opportunity to express their preferences that they didn't have before. In the cases in which the birth parents and the adoptees wish to meet and are both living, there have been countless successful reunions. And most importantly, in those states, the adoptees, I think, have been restored to a basic human right to information in government records about their own identity. So in sum, those are my basic points, and I would welcome any questions, and again, think that having an accurate understanding of this history, of the evidence, really supports doing in New York what other states have successfully done. Thank you.
Thank you. Would you comment, just as a legal, constitutional, whatever matter, balance the question of what has been said as the birth parent's right to his or her identity and to basically control who gets to know that, with the adult adoptee's right to have that knowledge?
Well, I guess I'd say there are kind of two different parts to that. I mean, one is this allegation that there's been some guarantee or promise, which I think is not the case. So there's not a danger of breaking that guarantee or that promise or negating what was offered as a choice. Otherwise, of course, a birth is a public event, as the courts have held in these cases. And when either parent is ready, willing, and able to raise the child, that parent has a right to do so. And of course, the other parent is liable to help support the child and can be sued publicly and held accountable. It's a strange concept, I think, to say that that child who is born does not have an equal right to the public document recording his or her birth. Mm-hmm. And there's no constitutional right to place a child for adoption. An adoption has to be approved by a court. The adoptive parents have to be approved as suitable. So again, there's no kind of reproductive right to place a child. Again, either parent becomes publicly accountable and responsible for the child if the other parent wishes to raise the child.
Thank you. Other questions?
Yeah, Professor Samuels, were you here when the two surrogate judges testified?
Yes.
What gave them the impression that there was, because it seemed to be pretty, consistent, that there was a promised anonymity, confidentiality given to the birth mothers, and that seemed to be the gist of their major objections?
Well, before I try and answer, I will say I was startled to hear that in the record there was some promise, because there is no such thing, written thing or guaranteed by law, so I don't know where that comes from. But I would say, and I've written many pages with many footnotes, that the social history is very complex, and that we did go through a period in the 50s after the war of a real, the women went back to the home, the men came home from the war, everybody was supposed to be married and have 3.4 children, and adoption was seen as a solution to the problem of the shamed unwed mother, who by giving up the child could then be restored and redeemed to her rightful place as a wife and mother, and we could seal the records, produce a false birth certificate. Birth certificates say the child was born to the adoptive parents, so the child then has the privacy protected, but with this false document. And everyone would go about their business and benefit from this. And the record for the adopted child, when you went into the court and county records, would be identical to the biological child. And there was a period of matching eye color, hair color, IQ, when children were kept for 6, even up to 12 months to make sure that they were A-OK to be adopted. They were really... so there's this kind of whole culture, I think, of there's no difference between the adoptive family and the biological family. And I think they're kind of, it arose because the records were sealed, because it was, considered a beneficial thing. There was kind of a belief that it should be secret, that some people shouldn't want to know, that they won't want to know. But curiously, when I went, my research actually started because I saw all these people searching for one another and benefiting from their reunions. So initially, I got my research assistant, and we said, let's find out why it was thought beneficial back when these records were initially sealed to the parties, to have lifelong secrecy. So the first thing I discovered was that the records were sealed much later than we in the Academy had generally believed. As late as 1960, in half the states, the records were available, and in some other states where they'd been sealed, there was still access to court records by adult adoptees, and even their adoptive parents of minor adoptees. So first of all, it all had happened later. Secondly, what I found was in the 40s, all the experts recommended that there be access, and there continued to be access. The National Association of Vital Statistics Executives, the first Uniform Adoption Act in 1953 recommended that the general practice be sustained, although New York had been an early outlier the other way, but recommended that the general practice be maintained of adult adoptee access to the records. So it really, in a sense, perhaps this is way too complicated an answer I'm trying to give, but it was a complex social as well as legal kind of series of interrelated events that kind of led to this kind of mindset. But I think what the witnesses are telling you today and what you all who are sponsoring the bill know is this was just kind of an experiment that didn't work. It kind of like, I mean, some people wanted it because they could cover their tracks. There is some skullduggery. But most people, I think, passed these laws thinking it was a good and helpful thing, and it just has turned out not to be.
Do we have copies of your research and reports? Have you contributed it to the committee?
I will send them. I gave you the citations and the links on the Internet, but I will send the full copies.
That would be very helpful. Thank you very much.
Just without citing inflammatory examples, this wouldn't be the first time in legal and social history that something that was being done to a group of people was characterized as being done for them.
Well, that of course, that was really the theme of my article.
Yeah.
That here it is, more than 95% of birth mothers are open to and supportive, and yet the opposition, when they come to testify, the opposition is they're trying to be protected.
Mm-hmm. Yeah. Okay.
Thank you.
Thank you very much.
Thank you.